If you were charged with theft, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So it's already been found, but this case is really old.
This is wild. The case is over 1,200 days old. That's more than 3 years of limbo. And yet, the defendant is getting another shot through a theft prevention course. Here's the real kicker. Judges love using these classes as a way to dismiss charges, but it's basically a last chance. Audience, do you think it's fair that someone can walk away from a theft charge just by completing a class years later?
So she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry. Just
Needs. N.
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though?
Walmart.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Okay. Can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer.
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay. This case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand?
Yes, sir.
You get no more resets after that.
Okay.
Okay. All right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
Sir, you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record. They'll see a prior DUI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify.
This is a heavy warning shot. The judge isn't just giving jail time. He's suspending the license to that's brutal for anyone who relies on driving for work or family. And here's the truth. Once you got a DUI on your record, every single traffic stop in the future becomes a potential disaster. Quick question. Should people with repeat DUI risks even get a chance at probation? Or is the judge right to go this tough?
Consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do?
Yes.
You plead to the offense guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you, Mr.
And Your Honor, if I may
Sorry,
mention, well, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that not all the evidence is in and that he does have the right to that. He has been in custody since January. He got transferred to ICE, which he says he no longer
So
wants to wait for the evidence.
you need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay.
¿Está
All
bien?
right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
Documentación de ahí.
it's against your.
Yes, Your Honor.
All right, come on up.
How you doing? Hey, Judge, good morning. This is Mr. Jalen Calhoun, Judge.
I'll sign this real quick.
Don't say anything about the case, okay?
All right.
Use the focus of this. Getting to the proper place to handle your business.
Who?
That's right. That's right. I'm so confused.
Scott Sanders?
Okay, what is his name?
His name is Jalen Calhoun.
Morning, Mr. Calhoun.
Good morning. What you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You are wanted out of,
Louisiana, Natchitoches Parish. I butchered the pronunciation, but.
Natchitoches.
Yes,
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see
Right.
what kind of person you are.
Right.
Paper really tells me who you are. The words coming out of your mouth, I just
Right.
right. So, tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, or equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle. We have a parallel charge with Louisiana where they're charging him for the theft, and we have for the driver.
But the thing about it is, I wasn't there.
Do you really think that you can just start spitting out something? Where do you think you are? Really?
My bad,
You think that this is helping you, Mr. Calhoun?
sir.
You're not at home. You're not on the street. Okay. Please.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they transversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they transversed state lines, they would be opposed to a bond. There was also, and because I took a charge, I know before the office reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So hold on a second.
Yes, Judge.
It's a stolen car
Yes, Judge.
out of Louisiana.
Yes, Judge.
They come to Houston,
Yes.
all 4 of them.
Yes.
How do we know the other ones knew that it was stolen? Do we have any kind of,
in Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that,
Oh,
but
no.
how do we know that they knew that it was stolen? Right? So what if I come pick you up in my car?
Oh,
It's
I
a
see what
stolen
you're
car.
saying.
You have
So-
no idea it's stolen.
I see.
Like if everything's ripped off in the inside, you got like, there's a screwdriver for the steering wheel, and the steering column's been ripped off. Then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen, and the fact that it was, well, at the time of I'm sorry?
That's still,
No, again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew, that's how the officers in Harris and the officers in Louisiana knew that they knew it was stolen because they were the ones who stole it.
they have them, you saying on video?
Yes, that's what
All
I'm
4
trying to,
together is taken?
yes, that's what I'm
Okay,
trying
well,
to.
that's something.
Can we see
different.
this video? I haven't seen this video. It's
You're
a,
not gonna get to see the video. That's what the
That's in
underlying criminal
Louisiana.
case.
you're basing your decision on a video that the prosecution has says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that
they're
there's a
because
video.
of a surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right, but we're talking about that.
Our criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was the only.
That's the only one.
Driver, right.
So your position on bond is what?
There's no bond against the flight risk. They literally fled the state the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing
saying
a car.
they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He
is-
is charged
he is
in
being charged.
Louisiana.
Well, then that's a,
He is charged, but in Louisiana.
okay, well, he's
Here,
being charged
he's
with
being
that.
charged
Just
with
because
the-
he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that it's stolen. Like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst. Let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen.
Now, here's a dramatic twist and ultimatum. The judge sets a bond, but gives the defendant just 2 weeks to surrender to Louisiana authorities. If he doesn't, that bond gets yanked and he'll be locked up until they drag him back. Basically, freedom on a countdown clock. Imagine that knowing the clock is ticking on your own release. What would you do in his shoes? Run or face ahead?
Well, you got to understand, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you. And then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct.
Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday at the latest. Monday, you'll be back in Louisiana Monday-ish, where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no bond. I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir.
What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes, sir.
He would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
You'd
client.
even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, I mean, I don't know.
I'll
So
talk to my client, Judge. Thank
Okay.
you. Appreciate it.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a servant's call and met with the complainant witness and stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
Oh, that's 10 minutes later.
That's 10 minutes later. Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom lip.
How is this?
I think we are omitting some things that's pertinent to the decision that you're going to make.
What?
that she asked, she or her daughter told her that you have to make a choice between
Oh, that's right. Yeah. I
and your
remember. And then she makes a choice of him.
and she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her or to hit him.
Can't consent
Well, but that's,
consent to an offense, Judge. If he
can't
tells me
consent
to
to an
shoot
assault.
me,
Yeah, no. I mean, you can, like,
Yeah.
boxers consent to
You can
assaults,
consent to
right?
assault. That's
But I mean, in this,
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her 10 minutes after this kind of initial incident happened. He's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
but there's a long cooling down period. You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it
still
fair that
assaulted.
she's not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious
Come up,
bodily
Mr. Sullivan.
less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that
Right.
occurs, you know? So
I would argue, Judge, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward. But I think that's.
and I think it'll work to the benefit, you know. So, Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. Don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand. And I don't know. But be it as it may, just don't have contact with this person. I think that, you know, it's just could be like a rumbling volcano. And the last thing we want to do is we don't want anything more to erupt. We don't want further charges and just, you know, and I think that, you know, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
Well, Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where there are five charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time, I've seen cases where the district attorney filed cases 1 year later, when they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
If I gotta put some money.
Go. Take your time. Just come back.
Okay, I will. Thank you.
Take care, sir. Great. This gentleman with you.
He is co-defendant with the other one, Your Honor. If I may, I'll wait. So I heard everything y'all said. You want to go first before I start my spiel here?
Which co-defendant?
Oh, yeah. What's the last name?
This is Doty. This is Doty, D-O-T-Y.
So, Mr. Doty, you're wanted out of the state of Louisiana for a particular charge. I think it's like a theft or whatnot of a car. Your lawyer, are you asking for a bond? Your lawyer's asking me to set you a bond, but I don't know. I've never met you before. I don't know anything about you. The way I get to know you is how you look on paper, because that really tells me who you are, whether to grant you a bond or not. The good news for you is that if it doesn't happen, we have so many buses coming in and out of Louisiana into Harris County because we have a lot of Louisiana people here that I'd say might be once, at least once, if not twice a week. There are buses coming in and out of here, shuttling people to and from Louisiana. Mr. Kim.
Your Honor, same as the previous approach is that this is one of 4 occupants of the vehicle of a vehicle that was stolen earlier that day in Louisiana, and they transversed the state lines, being apprehended in Harris County. State would be opposed to a bond due to flight risk of transversing state lines. The same day they stole the vehicle, felony out of Louisiana, where they were captured on surveillance video.
Any criminal history?
No, Your Honor.
If I may, Your Honor, he has no ties here. He lives in Natchitoches County, okay, Parish, I'm sorry. Apartment, what did I say?
A4.
A4?
H.
H4, Louisiana, zip code 71457. He lives there with his mother, Cynthia. He, 2023, got his GD from a program there called Ben Johnson. He also works at Pilgrim's Pride, which is a chicken plant. And so why are we holding him and paying him to pick him up? I would ask for general order bond, and he's going back to Louisiana. He's not staying here. That's where he lives. That's where he resides. And he can go post bond, get his lawyer, and deal with it. If he was charged with this in Harris County, this would be a criminal trespass. He's not the driver. The driver's charged in the 177th for unauthorized use of a motor vehicle. So if the appropriate charge in Harris County, if they had even been charged in Harris County, would have been a misdemeanor trespass.
I'm not going to give him a PR bond. I mean, he's a fugitive wanted from another state.
Well, he's an 18-year-old kid. I would ask if you would go lower than.
You need to understand, Mr. Doty, that actions have serious consequences. You're only 18. Are you 18?
Sorry.
How old are you?
18.
You're just now starting your life. And when you hang with dogs, you get fleas. We have enough people in there now that become statistics all they do is they end up running with the wrong crowd, end up with convictions, and essentially ruining their life. Once you become a convicted felon, it becomes extremely difficult to get a job, to get any kind of position of trust. People don't trust convicted felons. You don't get a good job when you're a convicted felon because no one trusts you. They're always going to think in the back of mind, okay, is this guy going to steal from me? Is this guy going to do this to me? Is he going to... You're on the road fast with what's happening now. Your lawyer wants me to give you a very low or free bond, but I can't. You are wanted out of another state. You are an inherent flight risk. And the problem is, any bond I set here now, because of the nature of this case, you're going to have to pony up a majority, if not all, of the bond because you're wanted out of another state. The thing is if you don't have anyone to pony up that money, your mom is a single mother, she's probably working her butt just to make it survive. You think she has enough money to just pony up money to get you out? This is what you need to think about when you start running with the wrong crowd. Because if you ain't got anyone to pony up money to get you out, you're stuck like Chuck until whatever happens with you. And I'll tell you now, more people plead guilty just to get out than they should. Because no one's going to wait 5 months just to fight a case. I don't know what an appropriate amount is, Greg, but it has to be sufficiently high that he's going to go back.
But he's going to go back. Was he going to stay here? He doesn't.
How?
He doesn't have anyone here.
How's he going to get back?
Gets out, calls his mom, and his mom provides transportation.
Have you talked to mom to see if she...
I'm going to call mom. I was going to see what the bond was, see if she can get him out.
Or call mom. I want to know if she's going to come here and pick him up, and then we'll talk.
Okay, thank you.
I don't want to set people up to fail, but if he's got no ride, if he doesn't have anyone, then...
Okay.
Thank you. Let me know, Greg. And hey, Greg, if she does, I'm willing to go a little bit lower.
Okay, I'll try to get a hold of her. Thank you. No.
That's fine.
Oh, good morning, Mr. Butler.
Good morning. How you doing, sir?
Your lawyer is asking for me to set you a PR bond, but you just picked up another case. Why are you looking at me all confused? You've got a long list of criminal history. You're on bond for a felony unauthorized use of a motor vehicle, and now you've picked up a theft. What happened in the theft, if you don't mind?
It is a retail theft, Your Honor.
Silly.
He was observed on surveillance video placing merchandise in a black suitcase he obtained from business and crossed all points of sale without attempting to pay. It was in Target, Your Honor.
You know, the funny thing is that it would only cost $100 to get you out of jail. You now know you have no one in this life that would even pony up $100 to get you.
Sir.
Why? You're just, why would we do this?
I was getting close. I had to. Okay.
I don't want you to talk about the case, but Mr. Butler, with all your criminal history, who do you live with?
I live by myself, but somebody is like living there, so I can't even get inside the place while they're good. So every time I go through.
I'm not giving you a PR bond so you can just go roam the streets. If he has, like,
I have an address.
some familial place, like a mop or, you know, uncle, aunt, I'd consider. I'm not letting you out just for you to go roam the streets and up to no more good. No, that's not what we're doing. So if you can figure out something, he's got some family or somewhere where he can go, and I know he's got a bed to stay at, then let's talk. But
Okay.
until that point, no, not to the street. You know, nothing good happens on the streets. And if I let you out, I'm going to have you come testing all the time because I don't want you using anything. Do you understand?
Sure.
Okay, so figure it out and then let's talk, but not to the street.
All right, appreciate it. Thank you.
You got it. You have the,
My question?
I haven't, Judge.
No, we're waiting for.
I'm ready when you are.
For my guy? Oh, they got
You
it.
can bring him out next.
Okay.
Good morning, Mr. Living.
How you doing?
Oh my goodness. You were wanted out of the state of Nevada for number 1, robbery with use of a deadly weapon or tear gas ×2. Burglary while in possession of a firearm or a deadly weapon ×2 counts. 3, kidnapping first degree with the use of a deadly weapon or tear gas ×2. Number 4, conspiracy to commit kidnapping first degree ×2 counts. And 5, conspiracy to commit robbery ×2 counts. Are you waiving formal extradition, sir?
Are you waiving the proceedings that we talked about? You want the 14 days? Yes, Judge, he's waiving.
Okay, good luck, sir.
Thank you, Judge. Does he need to sign it all?
He does. He needs to sign right there.
Okay.
If you need a pen, you got one?
I got one, Judge.
That was living. Living, I'm not done with you. You in Civil War? You want some? Get moving. Okay, thanks,
Thank you.
Ricardo.
Appreciate it. What's that call about the dirt bag? Okay, cool. What happened?
Lamar Mesa. Is discovery complete on this house? State.
Your Honor, there was surveillance video that we just put that, it's not body worn camera, dash camera, and surveillance video. I can prove that.
Please get on it. This case is 1,256 days old. If you ever take off on me again, I'm going to make your bond so high you're going to have teeth falling out. Do you understand? As of today, you will get an ankle monitor so I know where you are at all times. I'm giving you 30 days from today to make a decision on what to do in this case. We will either set you for trial or you must accept the plea bargain from the state in 30 days. And like I said, you ever take off on me again, your bond will reach the clouds. Do you understand? Where is this then from? Is this a co-defendant of the other one? I mean, are they the same day for real? Remember the one we had earlier today? Ms. Okafor.
Greg.
Oh.
Greg. What was that defendant? What was that one? Nieves was that?
Oh.
This one, it's not a code offending.
I'm ready. So where's this one from? Is this Target? Is this?
This is from J.C. Penney.
I'm ordering you as a condition of your bond not to go to any J.C. Penney for any reason. Do not pick up a new case. And I'm going to tell you now, Mr. Lamar Mesa, I'm going to do everything in my power to protect my community at all costs. If I find that you're a danger to my community, I only have one place for you. Okay?
All right, 30 days?
30 days.
Okay, thank you.
Do not leave until you sign our bond conditions. Don't worry about filing it because I'm having it monitored, so we can do it with Fleischer. All right.